members of the faculty, students, alumni, friends, distinguished guests, it's with great pleasure I welcome you to Georgetown University Law Center. We come together today to formally inaugurate the Paul and Patricia Saunders Professorship in National Security Law, as well as to recognize the official opening of the Center on National Security and Law. I'm happy to see members of our university boards and the Law Center's Board of Visitors and the Law Alumni Board with us here today. Thank you to each of you for joining us for this great occasion. Thank you as well to the friends and the family of Paul and Pat Saunders and the family of Professor Katyal, who are also with us. And special thanks to Pat and to Paul Saunders for making this day possible. Your generosity and service to our Law Center means so much to us. Can I ask you to stand? It's my pleasure now to introduce the president of the university, Jack DeGioia. For more than a quarter of a century, President John J. DeGioia has helped define and strengthen Georgetown University as a premier institution for education and research. Before assuming his presidency, Dr. DeGioia serves as a faculty member in a variety of senior administrative positions, including senior vice president responsible for university-wide operations and dean of student affairs. The service, leadership, and vision he brought to these roles were recognized by his appointment as the 48th president of Georgetown in July of 2001. He is the first lay president anywhere in the world of a Jesuit university. Dr. DeGioia is also a professorial lecturer in the Department of Philosophy. As president, he has significantly enhanced the Georgetown community. He oversaw the largest expansion of campus facilities in Georgetown history. Under his leadership, the university established the Berkeley Center for Religion, Peace, and World Affairs, the Neal Institute of National and Global Health Law, and a School of Foreign Service in Doha, Qatar. President DeGioia also addresses broad issues in higher education as a member of the U.S. National Commission for UNESCO and chair of its Education Committee, the MacArthur Foundation's International Commission on Education for Development, Policy, and Practice, the Board of Trustees of the Consortium of Universities of the Washington Metropolitan Area, the Executive Committee of the Business Education Forum. Dr. DeGioia is also chair of the Big East Executive Committee, and I'm not sure if that's given to you for winning 2 consecutive titles or by being that you're entitled to 2 consecutive titles, but we'll take it either way. Among his honors and awards, in 1998, he was named Young Leader of the Academy by Change Magazine, the American Association for Higher Education. In 2006, he was awarded the Distinguished Pro Ecclesia et Pontifice Cross by Pope Benedict XVI for his service to the Church. He has also received the Sons of Italy Foundation Lifetime Achievement Award for Excellence in Academia. As the first lay president of a Jesuit university, he places special emphasis on strengthening Georgetown's Catholic and Jesuit heritage with its inherent responsibility to foster peace, social justice, and interreligious understanding. It's my great pleasure to welcome to the podium President John J. DeGioia.
Thank you very much, Alex. And thank you all, including the members of the Saunders and Katyal families, for joining us this afternoon to officially recognize the Paul and Patricia Saunders Professorship in National Security Law and to inaugurate the first holder of the professorship, Neal K. Katyal. Georgetown, the experience and education that we provide is sustained and enhanced by the generosity and engagement of extraordinary members of our community, individuals who provide our students with outstanding examples of service and leadership, and individuals who, in the spirit of St. Ignatius of Loyola, engage in the world to make it a better place. In other words, individuals like Paul and Pat Saunders. Besides endowing this new professorship, over the years, Paul has continually supported our Law Center. He's a former chair of the Board of Visitors, a former chair of the Law Affairs Committee of the Board of Regents. He's been appointed a distinguished visiting professor from practice and has taught here over the last few years. He's also a member of our 1789 Society, comprised of the most generous philanthropic supporters of Georgetown, and in 1995 was presented with the John Carroll Award. Pat, too, has donated much of her time to our community and has served as a member of the university's Board of Regents. And two of their children, Michael and Paul, are also Georgetown graduates. We are a better university, a better community, for having Paul and Pat as members of the Georgetown family, and we're exceedingly grateful for all of their selfless efforts. For me personally, this is a very special moment. We have been friends for more than 2 decades, first being introduced to each other by our dear mutual friend, Father Timothy Healy. This afternoon, we are especially grateful for this new professorship in national security law. It will not only help enhance the extraordinary education that our law school provides, it will help prepare our students to face the professional challenges that they will encounter, and will help ensure that our law center is firmly positioned to address some of the greatest questions of our time. Questions about how to use the law to both combat the threat of global terrorism and to protect individual rights and civil liberties. With this in mind, I can think of no better person to serve as our first Paul and Patricia Saunders professor in national security law than Neal K. Katyal. Neal has been teaching at Georgetown for 10 years, and his talents as a professor, scholar, and lawyer have long been recognized. He is one of the nation's leading experts in constitutional law, particularly the role of the President and Congress in time of war and on theories of constitutional interpretation. In 2006, Neal won Hamdan versus Rumsfeld, a monumental Supreme Court decision which found that President Bush's use of military tribunals at Guantanamo Bay, Cuba, violated the constitutional separation of powers, domestic military law, and international law. As former Solicitor General and Duke Law professor Walter Dellinger put it, Hamdan is simply the most important decision on presidential power and the rule of law ever. Before coming to Georgetown, Neal served as National Security Advisor in the U.S. Justice Department, and he was commissioned by President Clinton to write a report on the need for more legal pro bono work. Neal also clerked for Supreme Court Justice Stephen Breyer, and his articles have appeared in virtually every major law review and newspaper in America. He was named Lawyer of the Year in 2006 by Lawyers USA, and runner-up for Lawyer of the Year in 2006 by the National Law Journal, one of 30 best advocates before the U.S. Supreme Court by Washingtonian Magazine in 2007. And among his numerous honors, he has won the ACLU Foundation's Roger Baldwin Award and the 2004 National Law Journal Pro Bono Award. The entire Georgetown community is incredibly proud of his achievements, and we are privileged today to officially confer upon him the Paul and Patricia Saunders Professorship in National Security Law. Neal, if you could join me here. This is how we do it.
Okay.
Put this right around. If an institution is defined by its members, then Georgetown is defined by the exceptional scholarship of Neal Katyal and the extraordinary spirit of service exhibited by Paul and Pat Saunders. For all that Neal, Paul, and Pat have given to this university, we have been enriched. The unique Georgetown experience has been enriched. And the practice of law, which preserves our freedoms and provides the foundation on which we build justice, this too has been enriched. So for this, on behalf of all of us in the Georgetown University community, I wish to thank you. And for all of you who are here today, very honored by your presence and grateful that you could be with us to celebrate this moment. Thank you very much.
I'd like to invite Professor Vietin to come forward and formally introduce the new Saunders professor, Neal Katyal.
Thank you very much, Alex, President DeGioia, family and friends, colleagues. It was with great pleasure and much greater humility that I introduce Neal Katyal. He is, first and foremost, a scholar of the highest caliber. His contributions to legal thought and his scholarly contributions are too numerous to name or even to highlight this afternoon. But suffice it to say that Neal Katyal has published major articles in virtually every major law review in this country. He has contributed opinions to every major newspaper in America, and he has appeared on every national news program in this country, including the Colbert Report. His interests are broad and his expertise deep. This year marks the publication of Professor Katyal's casebook in criminal law, but in addition, he is widely respected for his expertise in national security law, constitutional law, and in particular, the Geneva Conventions. In criminal law, he has advanced our understanding of cybercrimes, the law of conspiracy, and criminal deterrence. In constitutional law, he has written extensively on the role of the Supreme Court, presidential powers, the role of Congress and the President in interpreting our Constitution. More recently, and fortunately, he has focused his immeasurable intellectual talents on the most pressing problems facing our country and our world, advancing the scholarly research and lifting the public debate on questions of war powers, intelligence reform, and military justice. At this time, when our threats to our country loom large, when fears for our liberties run deep, and when war and crime overlap, and when all three branches of government are grappling with difficult questions of first principle, there is simply no scholar better equipped to lead us to a better understanding of how to protect our national security, secure our freedom, and preserve our Constitution. Neal Katyal is a gifted teacher. He is, of course, cherished here at Georgetown. But true to the Jesuit heritage of helping the less fortunate, we have lent his talent to others, most notably Harvard and Yale. Everywhere he visits, he is respected for his learning and his love for his teaching. At Yale, even as a visiting professor in 2002, he was voted by the students to be Teacher of the Year. Professor Katyal's influence and achievement are not only in the classroom and in the law reviews, but also in the courtroom and in the law reports. Professor Katyal has contributed to several landmark Supreme Court cases in the past decade, as co-counsel to Vice President Al Gore in Bush v. Palm Beach canvassing boards, and as counsel to the deans of major private law schools in Grutter v. Bollinger. He has also filed innumerable amicus briefs to the court. But of course, Neal is best known and quite rightly celebrated for his success as lead counsel in Hamdan v. Rumsfeld. Through his strategic leadership, dedicated case management, elegant briefs, and very adroit oral arguments, Professor Katyal transformed the case from quixotic to possible, from merely possible to the law of the land. In so doing, he not only transformed the legal landscape of the War on Terror, but he also laid the foundation for our constitutional structure for the next century. Notably, Neal donated his entire work on the case, well over 5,000 hours, to the pro bono effort. His generosity in this regard is matched only today by Paul and Patricia Saunders' generosity and down this chair, who by their contribution and leadership allows Neal to be Neal, and thereby to better Georgetown and improve our world. There's a particular reason why the Saunders chair is fitting for Professor Katyal, because even while thriving as one of the nation's top advocates, Paul Saunders moonlights here as a scholar. And as one of academia's brightest scholarly stars, Neal Katyal made his greatest impact as an advocate. Their shared vision of a bridge between theory and practice is perhaps best summarized by Professor Katyal when he wrote about his Amdan experience in the Harvard Law Review. And I quote, "Combining theoretical and practical skills was eye-opening, allowing me to see the ways in which practice shapes theory and theory shapes practice. Law school can think harder about how to train students to be lawyers and how to arm them with knowledge both about the practice of law and about its theory." It is this finely tuned sense of balance that makes Neal Katyal so successful and so celebrated. He is gracious in victory, measured in disagreement, and always deprecating his keen intellect with a good sense of humor. Scholar, teacher, advocate, public intellectual, colleague, and friend. Ladies and gentlemen, the Saunders Professor of National Security Law, Neal Katyal.
Thank you so Thank you so much, Viet. I'm so glad that my mom is here, so at least one person will believe what you just said. And I do very much appreciate the kind words, and I have three more thank yous before I begin my formal lecture. First, to my parents, my mom, Pratibha Malhotra Katyal, who's here, and my dad, Surinder Katyal, who passed away 3 years ago, whom I know would like to have been here, and my wife, Joanna, and my kids, who are over there, and my in-laws, Sydney, Estelle, Jeff, and Christine, all of whom have supported me at every turn. Second, to this school, Georgetown University, and my deans, Alex Zelenikoff and Judith Areen, and my president, President DeGioia. This place has been my home for a decade, and the mix of theory and practice, humility and excellence, has been unbelievable. I won't ever forget, everyone says, oh, this Hamdan is me. It wasn't me. It's this faculty and the students who stood behind me and helped me at every turn of the way. And without that, it would have been quixotic and it wouldn't have happened. It's because of the way this school, its students and faculty approach the issues that made the case possible. And the way we're going to approach the case we're going to approach these issues in the future with our National Security Center. So I want to thank Justin Florence and Matthew Gerke, our fellows who've worked so hard to make this event today possible. And finally, to Paul and Patricia Saunders for endowing this professorship. What you didn't hear about before is that I worked closely with Paul during the Hamdan case. He wrote one of the great amicus briefs in the case. He mooted me at the most critical time in the case. He actually knows something about law, unlike me. And I've watched his career as a great military attorney, as a top lawyer at Cravath, and I can quite honestly say there is no one, sir, with whose name I'd wear with higher pride than yours. Thank you so much. My goal in this lecture today is to offer a methodology to responding to the global war on terror. Now, it's become fashionable to either exaggerate the threat or downplay it, either side, for political advantage. And I don't think that we can or should lose sight of what happened on September 11th, 2001, with nearly 3,000 people dead, or what is likely to happen in the future with the rise of asymmetric warfare and individuals bent on hurting us. This is going to be with us for our lifetimes and that of our children. But I don't think that we should be so scared that we lose sight of what makes us a people, what makes us Americans. And that is sadly what has happened too much in the post-9/11 era. In policy after policy, the administration has taken actions that are contrary to our basic Declaration of Independence. You go back and you look at it. What were the colonists complaining about King George? Here are some quotes. He has rendered the military independent of and superior to the civil power. He has deprived us, in many cases, of the benefits of trial by jury. He has affected to render the military independent of and superior to the civil power by making judges dependent on his will alone. And finally, most tellingly, he has transported us across the seas to be tried for pretended offenses. The founders divided government and limited it in order to avoid these problems. And we now stand at a unique juncture where the president will no longer be the president on the 9/11 president, and the new president is going to inherit a world of foreign policy and national security challenges. What should she or he do? And what should the role of law and the legal academy and lawyers be in that process? The answers, I don't believe, are political, at least not in the sense of left versus right. I don't believe that President Obama is any more likely to get this answer right than a President McCain. I think these are incredibly hard questions, and the hard thinking has not often been done. And that's my goal in this lecture, to offer 6 principles that should guide what our response should look like. They are the following. First, compliance with past traditions where possible. Second, insistence on legislative action, not executive decree. Third, non-discrimination against aliens. Fourth, complying with the laws of war. Fifth, a limited use of federal courts. And sixth, the promotion of internal checks and balances, separations of powers brought into the executive branch. Now, these 6 principles are the result of a lot of litigation and academic writing that I've had in the area. And what I'm using this lecture today to do is reflect upon those lessons from theory and practice. Most of my practical experience, as you've heard, has been in the area of military commissions, and so I want to generalize out from that experience. But first, just so we're all on the same page, I want to tell you what a military commission is. So I was sitting in a friend's house in November 13th, 2001. The nation had been horribly attacked, and I saw on the bottom of the CNN screen, that crawler thing, it said, President issues military trial order for suspected terrorists. And I thought, well, that's interesting. When I was at the Justice Department, we kind of thought about this a little bit, but President issues it? That doesn't seem right to me. So I got on my friend's internet, and this was back during dial-up, and, so I didn't really, I don't even think Google existed back then. So I figured out whitehouse.gov or something, and I read this, and my first reaction was that I was on the spoof White House website. There's a joke one. That's what I thought I was on, because the president was saying, I, the president, am going to set up this trial system in which I'm going to define all of the rights. He later said 0 rights for the defendants. I'm going to pick the defendants. I'm going to pick the prosecutors. I'm going to pick what rights, what the rules of evidence are. I'm going to define the punishments. He predictably said the death penalty. And the last lines of the order went so far as to say the federal courts have no business reviewing what I'm doing at Guantanamo Bay, no right of habeas corpus. Now, I'm a big believer in presidential power, but I thought that went too far. And that's what the Hamdan case was about, the idea that maybe we need to have these military trials, which aren't anything like our courts-martial, our proud system of military trials that Paul worked in. But this is, not something by presidential decree. If we're going to break with the rules, we need to have Congress involved, and that's all the case was about. So when you hear me returning to that theme, that experience, that's what I'm referring to. Now, I'm going to define these 6 principles out for you today, and like any broad principles that we're generalizing beyond military commissions or one experience, sometimes they're going to conflict with one another. Tradition might work one way, international law another. And to add to the unsatisfactory nature of the criteria, I know many of you will be upset that I basically believe that the federal court should have a very limited role to play in the war on terror. That might strike you as odd for the person who you just heard argued Hamdan and struck down big parts of the Bush administration policy. I will try to carve out in this time we have a role for the federal courts that's limited, that properly constrains them to the areas in which their expertise lies. Now, before marching through these 6 principles in the time we have, I should warn you, I know I have a soporific effect on my students. They tell me this. I know you've all had busy days, and, I was reading my constitutional law exams. I know I have some of my constitutional law students in the audience, and I was reading the exams this time, and those of you who are maybe not as familiar with the Georgetown grading system may not know that we have gone to blind grading at Georgetown, which means you can't put your name on your examination. You have to put basically a serial number or something like that. And the idea is to avoid favoritism so that the student who's being really a little too nice to you all semester doesn't get a better grade. Well, we have at Georgetown very, very clever law students, and they figured out a way around this. So now at the bottom of exams, I get, oh, that was a beautiful tie you wore, or, hug your kids for me, and things like that. That's fine. You can discount all that. But this semester in constitutional law, I had a student who said, "Professor, should I have 1 hour left to live? I should like to live it in your class." So I'm thinking, wow, okay, how do we have an A+ at Georgetown? And then, it's a law student exam, so there's a footnote. Law students love the footnotes. And turn the page over. It says turn the page over, so turn over. That is because, Professor, you make 1 hour seem like an eternity. It's actually a made-up joke, but in any event, the first principle, respect for tradition. In general, compliance with executive branch precedent is a critical element in assessing the legality, in my view, of a president's action during armed conflict. In the crucible of questions surrounding war and peace, judicial precedents rarely will provide a concrete answer. As Justice Jackson said in the Youngstown Steel seizure case, a judge, like an executive advisor, may be surprised at the poverty of really useful and unambiguous authority applicable to concrete problems of executive power. Courts generally use prudential canons to stay silent, and for these and other reasons, the way in which past presidents have dealt with security challenges will often be a more useful guide than looking to what's in the United States reports. Presidents face pressures that are unimaginable to outsiders. And as another Youngstown opinion, this one by Justice Frankfurter put it, a systematic, unbroken executive practice, long pursued to the knowledge of Congress and never before questioned, engaged in by presidents who are sworn to uphold the Constitution, may be treated as a gloss on executive power in Article 2. And that was the central idea, as I said, about the Hamdan case, that we were the defenders of tradition, that it was the administration that had wanted to radically change how things had historically been done. And it's that key move that I think made that case possible. A lot of people advised us not to do that and to emphasize the new global regime in human rights that's come up. But we didn't think that we could capture 5 votes, or even if we could, that we should capture 5 votes with that type of argument. Instead, we wanted to use the court to recapture some of our founding traditions. That was the strategy. And so the opening lines of the oral argument, with Paul's help and others, we ask this court to preserve the status quo, to require the president respect time-honored limitations on military commissions. These limits, placed in the Uniform Code of Military Justice, require no more than the president try offenses that are war crimes and conduct trials according to minimal procedural requirements. These limits don't represent any change in the way military commissions have historically operated. In that opening, there were 5 different claims about tradition. The first was that the president was departing from the traditional way of treating war criminals, which is through a court-martial. The second, he was departing from the traditional rules for trial. Let me just give you one example. Hamdan was kicked out of his trial before it began at the voir dire. When I heard about this, I thought, well, it seems like a little technical thing. How big important is that? We went back and looked. No person in an American trial had been kicked out of their own trial. We have not done it. You have to literally go back to the Star Chamber in England for a precedent of defendants being kicked out of their own trial as long as they're not misbehaving or something like that. Third, we argued the commissions were trying made-up offenses that weren't actually war crimes. Fourth, we looked at the targets of the commissions. These were the first military commissions in American history that only applied to foreigners. We've had military commissions in the past. They started in 1847. They've always applied symmetrically to aliens and citizens. And they did in World War II when we captured Nazi saboteurs. This was the first one in which we said only aliens get this. And fifth, the president was trying to nullify the role of the federal courts by stripping habeas corpus. Now, we weren't the only ones relying on tradition. The Solicitor General stood up and said, we are the embodiment of tradition, and here are the opening lines of the Solicitor General's opening of his oral argument. The executive branch has long exercised the authority to try enemy combatants by military commissions. That authority is part and parcel of George Washington's authority as Commander-in-Chief of the Revolutionary Forces and was incorporated into the Constitution. So you have dueling claims about tradition, and that is implicit in the concept of law itself. It's natural to expect the adversarial process to produce disagreements, just as it does about the meaning of a constitutional text or a statute. But that doesn't mean that executive branch precedent is indeterminate. That was what some of, I think, the more radical Bush administration lawyers were saying, was that as long as there wasn't a half-bad argument you could make to defend the policy, you should make it. And so I don't fault General Clement, the Solicitor General, for making these arguments. He was left holding the bag after the policies had already been written. But the truth is these historical arguments were bunk. And I think even a first-year law student would see that. The problem was that the administration had basically run the process in such a closed, secretive way, literally 5 people, that none of this history, none of it was even debated. The judge advocates general were cut out of the process. The folks who do the laws of war, Condoleezza Rice and Colin Powell, found out about the military commissions on the day it was announced. This allowed something that wasn't tradition, it was a revolution to unfold. And our strategy, and I think the strategy as we think about the role of the courts, is to emphasize Burkean prudence and the dangers of departing from the long-established traditions of our country. And that's why I think the Supreme Court ruled the way it did when it said that the commissions violated separation of powers, American military law, and aspects of the Geneva Conventions. Now, this is an appealing argument for many of you, because here I'm pointing to a tradition that is rights-enhancing, not rights-constraining. But all of us know some traditions are rights-constraining. Let me give you one example from my work that's being published literally this week with a Georgetown student in the Stanford Law Review. The student's name, he just graduated, Richard Kaplan, about the NSA surveillance program, in which we outline a stronger case than the one the administration has offered for the legality of the NSA program. Now, the administration has argued that we're in wiretapping, in the NSA program, they were just simply doing what FDR and Lincoln did before, which was order the surveillance of Americans during wartime. But as constitutional scholars pointed out rather quickly, the problem was that FDR acted before the 1978 FISA, the Foreign Intelligence Surveillance Act, was passed. And the 1978 Act purported to say, if you want to surveil people, Mr. President, the way to do it is by going to this special court. And that is the exclusive way of doing it. So the critics of the Justice Department and the administration on the NSA program have said basically, well, that's a case, to use constitutional law jargon, that's about Youngstown Zone 2. When FDR acted, he was acting in the zone of silence. Congress hadn't prohibited what the president wanted to do. But now, when President Bush comes along, the argument goes, well, he's acting at a time when Congress has forbade what the president wants to do. The Congress has forbade this extra surveillance. And that's why it's unconstitutional. And you just heard a moment ago about all the laudatory words about Walter Dellinger, the Duke Law professor and former Solicitor General. Well, in this very room, Professor Dellinger said that the Bush administration created a vast expansion of presidential powers over FDR by confusing that zone of silence with the zone of prohibition. That Dellinger said there was no law, one way or the other, when FDR acted. Well, the problem, as Richard Kaplan and I show after we spent last summer in the National Archives, is that this story is actually bunk. And the administration's NSA program today turns out to be a lot closer to what FDR did than what even the administration has thus far argued. Then as now, Congress had a statute prohibiting certain interception of telecommunications, and the Supreme Court in 1937 had issued an opinion in a case called Nardoni that extended this to ban electronic surveillance. Then as now, the President, acting on the advice of certain advisors, adopted a dubious statutory interpretation in secret in order to conduct that surveillance anyway and to defy the Supreme Court in Nardoni. And then as now, senior advisors, including an Attorney General of the United States, warned the President that such surveillance was illegal. And then and now, some administration officials lobbied Congress for additional surveillance powers, saying that our hands are tied at the very same time as they were engaging in that surveillance. The secret history is rich. It's replete with all sorts of backroom deals between FBI Director J. Edgar Hoover and FDR. And there was a bypass of the Attorney General himself, the legendary Robert Jackson. Robert Jackson's memoirs later stated, "The only case I can recall in which FDR declined to abide by a decision of the Supreme Court was its decision that federal law enforcement officers cannot legally tap wires." And the upshot is that today's program looks really quite similar to what FDR ordered. And for those of you who believe that the pattern and practice of previous presidents should be a guide to today's actions and a template for what we should do, that precedent should loom large. At the same time, compliance with tradition can't settle everything because, of course, circumstances evolve. And it would be very unsatisfying, I think, for someone to defend executive branch precedent only when it's rights enhancing, as it was in Hamdan, and not when it's rights constraining. So we need to have some sort of serious way of thinking about it. And my answer goes back to what I started with Justice Frankfurter. Because what Justice Frankfurter said is that tradition is valuable when it's overt and when it's acquiesced in by the other branches. That can't, of course, be said for the FDR precedent, and that's why it ultimately fails to defend today's program. And even if, of course, a tradition is open, we still might not want to adhere to it. Think of the internment of 100,000 Japanese Americans during World War II. So the next question is, who decides when we want to break from tradition and precedent? And that brings me to the second principle, which is for action to occur through the legislature wherever possible. Now, I began with a really old-fashioned idea that I learned from 7th grade, that you need all three branches of government before you deprive someone of their rights. You need the Congress to pass a law, you need the President to enforce the law and not to pardon people under it, and you need the courts to uphold it. And if you do that, then you can deprive someone of the rights and alter the status quo. That is, the founders built in inertia into the system and a preference for the status quo. Now, against this structure, the Bush administration has sought to change the Commander-in-Chief clause into a textual warrant for unilateralism. And as broad as that power is, it is not unlimited. Even a strong defender of presidential power, like Alexander Hamilton in The Federalist, says the clause amounts to nothing more than the supreme command and direction of the military and naval forces as first general and admiral of the Confederacy, while that of the British king extends to the declaration of war. And our Supreme Court has recognized this most famously in the steel seizure case, when President Truman tries to seize the steel mills. And the Supreme Court says, quote, seizing the steel mills is a job for the nation's lawmakers, not for its military authorities. And the Youngstown idea is that the president can't, simply by donning his military garb, do what he cannot do what he could never do in merely executive dress. Well, what does that mean practically? It counsels the executive to go to Congress. The president can't just authorize military trials or NSA surveillance on his own. Now, to say that isn't to say there isn't some sort of emergency exception, and that's something we've been talking about throughout the day's events. You know, look, if it's September 12, 2001, and Jack Bauer captures the person who's planted a nuclear bomb, and he has 20 minutes left to interrogate the person before the bomb goes off and hurts, millions of people, then I think that the president does have a ability to say, well, there may be a statute prohibiting torture or whatever, but we can suspend it, or electronic surveillance, whatever the scenario is. Now, of course, that really only happens on Fox TV. It's not a real life scenario. And so it doesn't really guide, I think, should never guide our policy. But it's good and helpful to think about the fact that there is some sort of emergency situation. The question is, when do we use that emergency power? The administration's preference has been to resort to the emergency power at every turn. So we can't go to Congress. We can just do this stuff on our own and do it in secret. And that's dangerous for three different reasons. First, just practically, not going to Congress means your programs are vulnerable in court, as we see, as every single thing has been litigated and litigated and litigated. We're now almost 7 years in, not a single completed trial at Guantanamo, one plea. That's it. And that was like for 10 months or something like that. 7 years later. Second, eliminating Congress makes it hard for the president to build support, either international or domestic, for his programs. And third, eliminating Congress will mean that there will be less oversight on the process, and a process that will also change at the whim of the president. Now, going to Congress is often very hard. The administration has blamed Congress for sitting on its hands and asking the executive to handle everything, saying, well, the Congress is never going to do anything. Now, I'm not sure descriptively this is right. There's a chicken and egg problem here. And the problem goes back, if you think about it, to what James Bradley Thayer said about judicial review. Because his classic attack on activism was, if the courts are going to be activist and run social policy, then it's going to sap the will of the people to get involved. And just let the courts handle it all. Well, the same thing can be true about executive branch activism. If they read the Commander-in-Chief clause to basically say, well, we can do whatever we want and we can even ignore what Congress does, well, that's going to make it obviously a lot harder for Congress to act. And that executive branch activism problem is exacerbated by a particular feature of our Constitution in Article 1, Section 7. Article 1, Section 7 says all legislation has to pass both houses of Congress and be subject to a presidential veto. Now, convincing both houses of Congress to act is really hard. And the only way to obtain legislation that restricts the power of president often is to get it by that two-thirds majority to override a presidential veto. And so, if this is true, Senator McCain in 2005 convinces an overwhelming majority of the senators to ban the treatment of detainees, 90 of them or something like that. Well, the president can veto that bill even if there's a majority in the House for it. And even with that 90 or even 100 in the Senate isn't enough as long as you can't muster that two-thirds vote in the House of Representatives. And because members of Congress appreciate this voting dynamic ex ante, they're less likely to even introduce reforms in the first place. And that is particularly true with terrorism because it's a fluid situation in which technology is changing, immigration laws are changing, and the like. And so the costs of legislative action, the costs of decision are very high. The upshot is that we need to figure out ways to get Congress to act more often. One way to reduce the cost of decisions, and this is brilliantly pioneered by my colleague Viet Din, is sunset clauses. The case for legislative sunsets is, I think, a familiar one. Congress, faced with the crisis du jour, it may have a tendency to overreact in a time of crisis. Think about the Independent Counsel Act or something like that. Now, you might say, we don't really need a sunset clause because if Congress makes a mistake, you can just pass a law later on down the road to repeal it, and you'll just cure the difficulty. But in practice, that rarely happens. And if you look at our laws, we have all sorts of ridiculous old laws on the books. I kid you not. It's like illegal in the state of Washington, for a woman to drink coffee after 9 p.m. And there's another one saying that non-males dressing as Santa. It's criminal prohibition on that. Now, a sunset forces legislative action at time 2, at the time the sunset elapses. So Viet says the sunset, and the folks in the administration said the Patriot Act will expire, or some of its provisions, in 4 years, and force reconsideration. But it also has an effect at time 1, at the time of passage, because it lowers the cost of decision and says, look, we might be going too far, but we're going to have another chance to get at this. We'll have another debate about whether to do this or not, and maybe another sunset could be put into the law. Now, using sunset clauses makes legislation more attractive. But it also has a crucial feature that goes back to Article 1, Section 7, something I call the retrieval problem. Here's the problem. Whenever Congress acts in the war on terror, they run the risk that the president is going to twist their words. So if you think back to the simple words that Congress enacted just a week after 9/11 in what's called the AUMF, which means the Authorization to Use Military Force Resolution. Well, silly them, they said the president was authorized to use force because in secret memos the administration said, well, by force you actually mean all sorts of things, including the electronic surveillance on Americans, and that we can bypass this Foreign Intelligence Surveillance Court accordingly. Well, I'm going to quote that great liberal George Will on this. The next time a president asks Congress to pass something akin to the AUMF, the resulting legislation might be longer than Proust's remembrance of things past. Congress might stipulate all the statutes and constitutional understandings that it does not intend to repeal. But then perhaps no future president will ask for such congressional involvement in the gravest decision government makes, going to war. Why would future presidents ask if the present administration successfully asserts its current monarchical doctrine defending the NSA program? Now, to make matters worse, the courts sometimes deliver a 1-2 punch. You have the president taking an expansive view of the statute, like the AUMF authorizes electronic surveillance, and then it gets challenged in court. And then the president's lawyers go to court and they say, you have to defer to the president, national security emergency, you're a generalist court, you don't have competence. And so the courts say, yeah, you all know this a heck of a lot better than I do, and they defer. And then what happens? Now the Congress, even if they disagreed, even if there wasn't a single person who thought when they voted to use force that they were authorizing surveillance, they're stuck with that statute. Congress can't retrieve that power back, because to retrieve that power back, to pass a new law, to rein in that new interpretation, requires not just the concurrence of both houses by a simple majority, but by a supermajority, due to the features of Article 1, Section 7. And this, I submit, is a key reason of why Congress doesn't act. Part of it is this Thayer-esque sapping of the will of the people, but part of it is also that they're worried that by giving this power, it'll be hard for them to retrieve it back. And the sunset, of course, prevents that, because it resets the statutory baseline to 0, demanding that Congress pass something new. Now, in a Coasian world, of course, this wouldn't matter. Whoever has the initial entitlement, the president or Congress, won't matter, because if surveillance is appropriate, we'll reach the right decision, and if it's not, then we won't. But Coase, of course, assumed 0 transaction costs, and while that theory may work well at the University of Chicago, here at Georgetown University, with that magnificent building by William Thornton 2 blocks from here, we know all about transaction costs. And if Congress knows the slate is going to be wiped clean in a few years, they won't have to be scared about every possible ludicrous interpretation that a president is going to take in secret. And they may also know that a president ex ante is going to be less likely to take radical interpretations, precisely because they know that the statute will be up for reauthorization. The third principle, equality. This one begins with an anecdote. I remember the first time I went to go see Mr. Hamdan at Guantanamo. I'd been trying to go down there for months, and they made it hard for me to get there. I'd already argued his case in the district court. And I went down, and it took 30 hours, basically. They really don't make it easy as for a defense attorney, and which is understandable. Get down, and I go into the barbed wire and so on, and go into the room where I'm meeting him. And I'm pretty nervous. I don't do criminal defense work very often, and certainly not at Guantanamo. And I go there, and he looks at me, and he says, "Everyone else must leave the room, except the translator." And so I think to myself, I am going to get yelled at. I mean, the man had been there for 3 years, 10 months in solitary isolation. Thought he had a right to yell at me. It's fine, but that's what I thought was going to happen. And instead, he looks at me and he gives me a smile and he says, Neal, I want to know, why are you doing this? Why are you representing me? Charlie Swift, who is my fantastic military co-counsel, Charlie Swift tells me, your last client was Al Gore. Why do you go from Al Gore to me? And I was totally taken aback by the question. And I was so taken aback, I paused for a long time. I remember it was like 30 seconds in, and I'm thinking, boy, This is not the way you're a lawyer. You're meeting a new client. He asks you a simple question and you can't answer it. This is awful. And then at about 40 seconds, and I think to myself, well, you know, when Justice Ginsburg is asked a question, she often pauses for a while before answering it, so maybe I'm okay. And then at about 45, 50 seconds, and I think to myself, you know, that doesn't matter. He doesn't know who the heck Justice Ginsburg is. And then I gave him this answer, and it's the part that's motivated me the most in this case, in this set of issues. I said, you know, the reason that I'm here is that my parents came to America with $8 in their pocket, which is all they were permitted to bring out of India. They didn't come to America because of the quality of its soil or because of the sports teams. They came to America for a simple reason. They could land on its shores and they'd be treated fairly and their children would be treated fairly. And when the president issued this military order, which said, if you're one of them, if you're a green card holder, as my parents were, or if you're a foreigner, one of the 5 billion people, you get the beat-up Chevy version of justice. You get sent to Guantanamo. But if you're an American citizen, accused of the most heinous crime imaginable, the detonation of a weapon of mass destruction, you get the gold standard. You get the American civilian trial. I told him that's why I was so offended, because we haven't ever had us versus them justice. And while all of that was almost verbatim, I didn't say this, but I'll say it to you in this academic setting. As a person who teaches constitutional law, I think back to those majestic words of the 14th Amendment, equal protection of the laws. Who is it guaranteed to? Well, it's guaranteed to persons, all persons. That's the text. And why does it say that? There are other parts of the 14th Amendment that talk about citizens, special rights for citizens, like social rights and the Privileges and Immunities Clause. But Representative Bingham, who wrote the 14th Amendment, said, I need to overrule the worst line in the worst Supreme Court case in American history, the line in Dred Scott versus Sanford, which said only citizens have constitutional rights. Representative Bingham said we fought a war about that idea, and that's why it reads persons. And indeed, the Congress passed right away 2 laws that made it a federal felony to give aliens different punishments than citizens, and those laws are still on the books today. And there's a deep logic to insisting on equality. It goes all the way back to Chief Justice Marshall's opinion in McCulloch versus Maryland and the Privileges and Immunities Clause, which is you don't have to set a substantive standard. As long as you insist on fair treatment, equal treatment, you're basically going to get a good result in the end. Not always, but you're much more likely to do so. If you think about what Justice Scalia said in the Cruzan case, he said, our salvation is the Equal Protection Clause, which requires the Democratic majority to accept for themselves and their loved ones what they impose on you and me. And Justice Scalia's comments track those of Justice Jackson years earlier, who said, the framers of our Constitution knew nothing opens the door to arbitrary action so effectively as to allow officials to pick and choose only a few to whom they'll apply legislation and escape the political retribution that might be visited upon them if larger numbers were affected. So the idea here, and particularly for the war on terror, in which the boundaries are really hard, these are really hard substantive questions about how much liberty to give them or not, the idea is to insist on equality and make the rules symmetric between aliens and citizens. And by doing so, the more powerful, that is the citizens, will virtually represent the less powerful, the aliens. And the breakdown in parity between aliens and citizens is a very disturbing new trend. Even if you go back to those horrendous things in World War II, the internment of Japanese Americans, they applied symmetrically to citizens and aliens. General John DeWitt testified before Congress, a Jap's a Jap. It makes no difference whether he is an American citizen or not. Now, some disagreed. The late Chief Justice Rehnquist said the problem with the detentions in World War II was that it applied to citizens. If it applied to aliens, it would have been okay. Well, entirely missing from that account was any thought about, well, maybe that would have actually made it worse, because at least the one thing that you could say, and be it a minor one, in favor of what happened there, is that it applied symmetrically, and so there was at least a chance of some process in that. Now, the laws of war today have moved to reflect this basic equality principle. Article 102 of the Geneva Conventions, for example, now says you treat aliens, enemy aliens, the same way as you treat your own members of your own armed forces. And the idea is that the rules for courts martial you apply to your own troops must be fair, must be pretty fair, and if you apply it to others, then you'll have the logic of reciprocity and get a better result. And fidelity to these precepts, far from undermining the war on terror, seems to be the best way to win it, by demonstrating America as not being unfair, and by subjecting those from foreign lands to the same justice as Americans face. America projects not only benevolence, but strength. America's soft power depends in no small part on being able to rise above being scared and to highlight the vitality of our system. Carving out special rules for them and different rules for us is no way to win respect internationally. And those of you who were in this room and heard Lord Brenda Hale just a few months ago, the law lord from Britain, know this story. Because the law lords in Britain recently decided a case called A versus Secretary of State, and they struck down the terrorist detention policy on these equality grounds. As the majority put it, the principal weakness in the government's case lies in the different treatment according to nationals and non-nationals. The government has vouchsafed no persuasive explanation of why national security calls for a power of indefinite detention in one case, but not the other. And sadly, the experience of Britain is far truer to our own backbone of equality than our recent American one. Although our founders broke from the British in part because of the idea because they didn't respect the idea that all men were treated equal, it's now Britain that is teaching us about these words. Now, thinking about Britain reminds me of the fourth principle, which is compliance with the basics of international law. Now, this is not controversial as a goal. The hard question is how much weight do we give international law? And I think the appropriate amount of weight turns on what we mean by international law. It comes in two flavors. One, treaties and statutes that embody international law understandings ratified by the democratic processes, the Senate or the House and Senate. The other flavor, customary international law, which arises from custom. It's kind of tradition-based. It's a common law idea. Now, I have no problem with the idea that treaties should bind us, assuming that the treaty is itself constitutional, which is a deep and difficult question that Professor Rosenkranz has dealt with. But I do have a problem with saying that Americans are bound by customary international law. There's, after all, a massive democratic deficit with customary international law. It's totally bypassed American processes. Now, that notion might strike you as odd coming from someone who is identified at the left of these sets of issues on the war on terror instead of the political right. But here I don't think it's that counterintuitive. And if you want to look at it, Exhibit A is the military commission process itself. Because the law that military commissions applied was not American criminal law, the laws of material support and so on that Congress has done. It wasn't the American military law, the rules of courts-martial. It was customary international law. It was they derived all their procedures, they said, they actually invented some new ones, but they said they were deriving them from customary international law. That was their justification. I kid you not, when I argued the case in the D.C. Circuit, the attorney for the government stood up and said when the judges were asking him, how can you kick a defendant out of your courtroom? He said, well, the law of Rwanda allows it. As we stood up afterwards and said, well, you know what? We live in America. We don't really care what the law of Rwanda has to do with the rules for criminal trial. You can't import customary international law ideas on fundamental questions of justice. But here you have a tremendously odd thing where the so-called conservative judges and advocates are claiming international law governs. And I think we should resist this notion. America can voluntarily cede its sovereignty away for its interests. Our founders recognized that, of course, by giving the Senate the power to ratify treaties. But that's the process, not a vague, shadowy, undemocratic process of customary international law. And the focus on the American process brings me to the fifth and perhaps most controversial proposal, that there should be a limited role for federal courts. Now, I've previewed this argument already. I believe that substantive freezing by federal courts of law is generally a dangerous thing. And I believe there's two large procedural roles for courts in the war on terror. The first is when legislation hasn't affirmatively authorized what the president has done. That's the idea in Hamdan. The second is when the legislature has authorized action that invades fundamental rights and only against aliens, the non-discrimination principle. But even that limited conception of a court, which I admit is limited, and I'm sure to many of you in this room is particularly too limited, but even that was too much for the administration. They went to court. 4 days, we found out we got certiorari by the Supreme Court on November 7th. November 11th, they got their friends in the Senate to run to the floor and say, the terrorists are taking over our courts, essentially, and we need to strip the Supreme Court of the ability to hear Guantanamo cases. And they passed a vote by 49 to 42 to strip the Supreme Court of the ability to hear Hamdan. Something that hasn't really happened since the Civil War. And I went from being a pretend lawyer to being a pretend lobbyist very fast, and educating the Senate and the House later on what they had done. And ultimately, they changed the law a bit. Not too much, but a bit, so that we could possibly argue that Congress intended to grandfather our case. And, the Supreme Court ultimately agreed with us. And I remember, I can't emphasize how important this is. I think this is the most important part of the case. It's not Geneva Convention, all that. This is really something fundamentally different than all the technical lawyer arguments. I remember I came out of the Supreme Court when we found out we won, and all the media are asking, what does this mean? What is this uniform code of military justice, right to tenure trial, this, that, and the other? And I said this is almost verbatim. I said, the thing that happened today is far more than the deep technical debate. It's something much more fundamental. It's this idea that you have a man, a fourth grade educated Yemeni, Salim Hamdan, who's accused of conspiring with one of the world's most evil men, Osama bin Laden. He was alleged to be bin Laden's driver. And he brings his case not just against anyone, he brings his case against the President of the United States, the nation's most powerful man, the world's most powerful man. He brings his case there, and he brings it all the way up to the highest court in the land, the Supreme Court of the United States. And he wins. That's something remarkable about America. In many other countries, Mr. Hamdan would have been shot for bringing his case. More to the point for me, his lawyer would have been shot. It reminded me of something that then Judge Roberts said at his confirmation hearing. He said, the great thing about the Supreme Court, and I'm very loosely paraphrasing here because it's way more eloquent than I, but he said the great thing about the Supreme Court is that on the one side of the courtroom, you can have the big fancy corporation represented by the big fancy law firms, the Cravaths of the world. And on the other side, you can have the little guy. And he's got none of that. He's got no big law books or fancy law firms. But if he's got a good idea, and the idea is right in law, there's a chance he's going to win. Not always, but sometimes. That's something fundamentally great about our American process. That's our gift to the world, that we think our system can tolerate checks on the president, that we can even say, the president, you actually got something wrong. You made a mistake. We think our system is strong enough. That's not weakness. That is vitality. And that's certainly not the law of Rwanda, but it is emphatically the law of the United States of America. Now, there are going to be times when courts are going to have to make substantive decisions. I don't think that they should have zero role, but they should be minimized. And one way to minimize their role is to think about the sunset process that I spoke about legislatures applying to judicial decisions. And if you think about it, right now we're asking the federal courts to do way more than we're even asking Congress. And so we might really want to think about, can we sunset a judicial opinion? Some of the case for sunsets, for judicial sunsets, is the same for legislatures. That is, people will overreact in a time of crisis. They have limited information. There's a too human desire for security to trump abstract notions of liberty and the like. And if you think about it, the judiciary has two features which make a sunset even more attractive. That is, that they're unaccountable. You can't vote the federal judiciary out of office if you disagree with them. And their decisions are entitled to stare decisis. So they go on for years and years and years. And so, it's interesting. The lack of attention to judicial sunsets is surprising given the fact that one of the more famous cases in recent years, Grutter versus Bollinger, had a line in Justice O'Connor's opinion. This is a case about affirmative action. And she said, "We expect that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today." Well, on that reading, what she's worried about is essentially affirmative action lasting into perpetuity. And regardless of whether the reading of that as a sunset is correct or not, you can see what I mean through it. You can basically say the Supreme Court can issue an opinion, but it'll only be good for a certain number of years as binding authority. or until a certain event happens, cessation of hostilities or the like. After that time, it simply becomes a persuasive precedent, but not a binding one. It'll be like an out-of-circuit precedent. It'll be persuasive, not binding. And in short, my idea here is that notions of judicial restraint should incorporate not simply Sunsteinian minimalism, that is broad decisions versus narrow preference for narrow decisions instead of broad ones, but also notions of judicial restraint over time. That we should think about shortening the amount of time that a Supreme Court decision is binding in this area. And there are two reasons for that. First is error correction. As human beings, judges are necessarily going to make mistakes, and mistakes are particularly likely to occur in this area because it strays from judicial competence. Now, instead of using devices that minimize the impact of judicial errors, our judicial system magnifies them. Both the doctrine of stare decisis and the idea that the Supreme Court has superiority over lower courts exacerbates the impact of a mistake, the former over time and the latter over distance. Now, some might say a judicial sunset isn't necessary because the Supreme Court can overrule itself, but that's rare. It takes many years, and sometimes even when they make mistakes like Plessy versus Ferguson, they don't really admit it. And of course, the Coasian gambit here is the same as the one before with the legislature. It replaces reality with a formalism that isn't true. It's very hard to overrule decisions, and it's particularly hard with litigation. And that brings me to the second reason for a judicial sunset, which is agenda setting. Without a signal that a case is open for reconsideration, political actors and private parties are unlikely to take decisions that are going to flout precedent. A Supreme Court decision is understood to be binding law, and you don't want to march up against a Supreme Court decision. And if that task is really hard for potential parties before courts, it's even harder for lower court judges who are, after all, under orders to obey the Supreme Court and not to anticipate an overruling of a Supreme Court decision. A judicial sunset will put everyone on notice, the litigants and the lower court judges, that a precedent is open for reconsideration. And it'll lead the parties to start to develop a factual record as to why a particular judicial rule should be maintained or overruled. And routinely today, we're given as the answer to the most thorny national security dilemmas of our day the idea that some long precedent by 5 justices who are generalists governs us today. You know, our military commission's constitutional. Look to what the court said in 1942. Do aliens have habeas corpus rights? Look to what they said in 1950. Well, the debate here is stultifying and unilluminating. The answers are not often going to turn on this handful of justices and what they thought a long time ago in a different world. Justices, unlike the political branches, don't have the institutional competence to make binding decisions in this area, one that adequately reflects threats and social norms over the long term. And that brings me to the last and final principle, which is internal checks and balances. Precisely because courts have a limited role, we need to depend more on the executive branch. I don't pretend for a moment by simply standing up before you and announcing 5 principles that the world is going to get better. And I don't think that Congress will always act, and I'm not sure that the courts will rein the president in when the president acts too broadly. And so we need to think more about replacing or overarching reliance on external separation of powers, the 3 branches, into one that molds more of the checks and balances into the executive process itself. And we can start by trying to resuscitate a dirty word in America today, bureaucracy. The structural advantage of bureaucracy is that it empowers a group of long-term players to accrue expertise in particular subjects and check the political actors. Now, for that bureaucracy to have the function I'm envisioning, 2 things need to happen. And both are controversial. Lena Kagan, the dean of Harvard Law School, has, at least in the domestic context, weighed against this. But I think there's a strong virtue for it, particularly in foreign affairs. First, you need to set up bureaucracies in partial competition with one another. When the Defense Department has to convince the State Department about who's right on a particular issue, you're going to get a better decision. Overlapping jurisdiction, that bureaucratic friction, is going to produce a healthy tension and better decisions over the long term than simply giving the decision to a secret 5-group body of people who think the same and act the same. Second, we need to transform bureaucratic service into something attractive. In France, if you look at it, the top graduates of their universities go into the civil service. In America, that rarely happens. People might want to go in and be political appointees in the agencies, but they don't want to actually work in the agencies themselves. Now, at least one American institution does work differently, and that is the Foreign Service. Comparatively speaking, they reward employees and discourage spoils and create extensive opportunities for promotion through their up-or-out system. Perhaps most impressively, the State Department has something called the dissent channel, where you can, if you disagree, you're a State Department employee anywhere in the world, you can disagree and write a cable to Washington where it gets read by the elite Office of Policy Planning. They have to respond within a certain number of days, substantively, and explain why the policy decision is made for the way it is. Sometimes those decisions get reversed because of people protesting in the dissent channel. And far from suffering retaliation, the people who use that channel have often been promoted. So that's what I'm envisioning. Bureaucratic friction that starts to drive better policymaking. Now, for that to happen, you need a decision maker that is going to be impartial when there are conflicts. And the decision maker right now is the Office of Legal Counsel, abbreviated OLC, at the Justice Department. Now, they have two roles. They are to advise the president and to adjudicate disputes. And I think these two roles are in fundamental tension. And the result of combining them is inexorably to give the president advice that he wants to hear. Now, over the last 5 years, the Office of Legal Counsel's judgment has been atrocious. Now, let me set this to you in context. If you're the president, it is incredibly hard to lose a case in the Supreme Court in a time of armed conflict. It's kind of like failing a class at Yale. You really have to try, okay? But they've managed to do it not just once or twice, but repeatedly. They said in November 2001, OLC said you can have these military commissions. Supreme Court said no. They said, another memo, they said you could detain people at Guantanamo with no statutory right to habeas corpus. Supreme Court said no. They said you don't have to give them any Geneva Convention protections. Supreme Court said no. They said that you don't have to give them, if you detain American citizens, you don't have to give them essentially access to lawyers and due process. Again, the Supreme Court said no. And I haven't even gotten to the NSA opinions or the memo that was just released about torture. Now, on legal questions, agencies are bound to have differing views. Colin Powell is going to have a different view than Secretary Rumsfeld sitting when Powell is sitting as Secretary of State. And that disagreement is healthy and natural. But you need a decision maker that's not masquerading as a quasi-judge who's secretly a kind of a pep leader for one side. Otherwise, if you don't have a neutral adjudicator, this so-called OLC courtroom is going to look like a third world courtroom, where political influence is what guides decision making and not the law. But the political pressure on OLC is immense. They're all political appointees at the top of the leadership, and there's simply no way, I think, that OLC's aspirations to be neutral can work in practice. And for that reason, I think the Office of Legal Counsel needs to be split into two separate roles, one that advises the president and one that adjudicates disputes. And that adjudication function will be transferred to a separate body, a cabinet-level body, to resolve these disputes. There's a whole variety of other approaches that one could take, but I think the big point here is to think about putting the checks and balances into the executive branch instead of always relying on the external ones of Congress and the courts. So, in conclusion, it is, my view that we should aspire to these 6 principles. And we won't, of course, get all 6 of these all the time, no matter what enlightened leader we have in the future. I don't think we can. But I do think we'll do pretty well if we try. Yes, we can, as Senator Obama would put it, or as Senator McCain recently said, I believe as strongly as ever that it is within our power to make in our time another better world than the one we inherited. For me, while Hamdan didn't implement all 6 of these principles, it did pretty well. And the point was driven home to me when 2 weeks after Hamdan, I went to Seattle to give my first set of public remarks. That's where we'd filed the case. So after the decision came down, I wanted to return to the place. And I got there, and there was a big audience, a lot of people, and my wife, poor Joanna, she hates this darn thing. As an academic, you don't have to have this BlackBerry, but as a lawyer, sadly, you live by it. And so I'm used to checking the BlackBerry, and we were dealing with Congress on some things. So I look at the BlackBerry, and before I'm getting up to speak, and I get this email from a man who's an apple picker somewhere in the state of Washington, and he says, Neal, I really wanted to be at your talk, but I couldn't be at your talk for whatever reason. And I wanted you to have this quote. And the quote is from Justice Rutledge dissenting in the last great military commission case in World War II involving the war crimes for General Yamashita. And here's the quote. More is at stake than General Yamashita's fate. There could be no possible sympathy for him if he is guilty of the atrocities for which his death is sought. But there can be and should be justice administered according to law. In this stage of war's aftermath, it is too early for Lincoln's great spirit, best lighted in the second inaugural, to have wide hold for the treatment of foes. It is not too early, it is never too early, for the nation steadfastly to follow its great constitutional traditions, none older or more universally protective against unbridled power than due process of law in the trial and punishment of men, that is, of all men, whether citizens, aliens, alien enemies, or enemy belligerents. It can become too late. This long-held attachment marks the great divide between our enemies and ourselves. Theirs was a philosophy of universal force, ours one of universal law. Every departure weakens the tradition, whether it touches the high or the low, the powerful or the weak, the triumphant or the conquered. Now, I'd read that quote before because, years ago when I filed this case, there weren't, fancy receptions and brass bands playing. It was tough, and there was a lot of disagreement about the case. And it was a controversial thing, and people in the administration had strong feelings. And you look to quotes like this for solace. You think to yourself as a lawyer, there's a higher principle at stake, and that's why you're doing what you're doing. But this apple picker had a kicker. He said, Neal, I'm not sending you this quote from the United States Reports, the official publication by the Supreme Court. I'm sending it to you from a book chapter written in 1956 by a young former law clerk to Justice Rutledge. That law clerk's name was John Paul Stevens, and exactly 50 years later, in Hamdan versus Rumsfeld, in writing the majority opinion, Justice Stevens made good on his former boss's principled promise. Thank you very much.
Thank you, Neal, and congratulations again. This concludes this portion of our event. I invite you all to the Sport and Fitness Center for a reception immediately following. And if you would stay in your seat until the faculty has recessed, that would be terrific. Gentlemen.